Don't be afraid. Okay. Don't be afraid to try to answer the questions, even if you might mess up and make a mistake. By trying is the best practice to try to formulate your thoughts and speak up, and that's how you learn to be a good lawyer, learning to argue. And I told you last time that every class is going to lead a little bit into the next class, and you need to, as we go along, think about that everything is connected, and not just we're not studying one subject and its issue is separate for another one. All of these things are related, and you'll see we're and today we're going to talk about 3 of the cases. The good news for y'all is I'm such a nice law professor. Unlike the American law professor, I'm not going to keep torturing y'all with too much to read. So I gave you a lot of cases, and y'all have just, like, I'm sure, struggled to read and make sense of all these cases. But we're only going to talk about 3 of the cases today, and then we'll talk about the rest of them next week, which means what? You don't have any new reading assignment. Yay. Everybody can be happy. But you probably will have to go back and read these cases again, because you might have to read them 3 times to start understanding, especially after we discuss it. But it's very important to understand American and English law, for y'all to learn how to read these cases and struggle through and fight. Because if you can't read and understand cases, you'll never be able to practice law in the United States or with the United States lawyers. And everybody, I know y'all think, I want to skip all this history and theory and all these old cases from England. I want to go straight to writing my, contract for my international distribution of my movie. But you have to understand some of the basics. And some of the cases we're going to talk about today shows how this English American common law grew out of these theories, and you have to understand the theories to understand the cases. Not only to understand the law as it is, but you need to understand that you can see from these cases the law and in this common law system is always changing. Some of the stuff in these cases is kind of historically crazy. You can't imagine that anybody would go in court and argue about some of these things today, but you need the foundation to be able to argue for new law. One of the things you might do as an attorney, I've done it, I can tell you about some of my cases, has gone in there and said, well, this is sort of what the law is historically, but that's crazy, and we need to change it, and the law needs to evolve. And some of the decisions that have been handed down by judges get a lot of respect, and in the United States, it's very hard. You can't just go and say, "Oh, the judge is crazy." They get a lot of deference and a lot of respect, but they're not always right. And the problem with a system that's based on precedent, if one judge messes up, misconstrues the facts, applies the legal theory wrong, then you end up with a precedent that now everybody's trying to follow the precedent, and the precedent is all screwed up. And so sometimes, and I've had to do it, go back and try to correct and say, back here, they did not get the law right, and we need to correct it so that the law can evolve and move ahead the way it should. And contract law in the common law system has always developed to try to facilitate the system of commerce that y'all all want to be in, because I know y'all all want to go do movie contracts and McDonald's franchises and all these, great international contracts and work with the American companies coming over here to build bridges after the Russians get kicked out of the country and everything else. But you need to understand some of this, not only what the law is, but how it works and how it got to be the way it is. And that's especially true. Okay. So how's about on Andreevich Beza? Are you on the Zoom? Can you tell us what Fletcher versus Peck was about? Okay. We don't have Andre. What about Anastasia Fedorovna Kuzmich?
Sorry, it's first case, which was on the first lecture?
Yes.
Oh, okay. It's about selling the land. Yeah.
And what about selling the land?
Oh, I don't remember.
Can somebody help her?
Oh, I forgot.
Well, that land, if I remember correctly, that land was sold for a very low price. As you said, it was like 1 acre for a cent, something like that.
Right.
And it was like a ridiculous price for that time, especially for nowadays. Yeah, and that was the case. And you said that case doesn't really make sense because don't really make sense because I don't know how to say it.
Well, what did the court base its reasoning on? The court said you can't overturn these contracts. Why?
Yeah, that was the point that Fletcher, he didn't have a real reason to go to the court. He got his land for a good price. Yeah, but he did it, and they won that court, I guess, if we can call it like that.
Well, the party who was trying to overturn the contract lost, because the court said the contract is good. We're not gonna cancel all the contracts because of the original fraud and the original corruption. And what I said was strange about the case was that the court said none of the people who bought the land later knew about the corruption. Who believes that? I don't believe it. But that's what the court said. And it's interesting the way common law works in the history. All that part of the case is forgotten. Nobody goes back and thinks about, oh, that was wrong. What has happened was the important principles have been taken out of the case and continue through history. And one of which is what you see in the other cases we're looking at today, this Hay versus Brooks and Springstead versus Nice and Daugherty versus Salt, it's all about freedom of contract. And it's about that's the underlying theme of the development of our society, of the freedom of people to enter into economic transactions voluntarily. And it's very different from the days when, in England, where the king told everybody what to do, or the days of the Soviet Union, where, Stalin would say, we're going to have a 5-year plan and the government's going to tell people what to do. This is what we're going to build and this is what we're going to sell. It's all about individuals working. And it's important for y'all to understand that idea of economic freedom is very related in English and American history to our idea of political freedom, that people, for the most part, government doesn't tell us what to do, and people are free within certain, bounds to do what they want politically and economically. And you see going back, the English courts struggling with this theory, and maybe not doing it that well all of the time. But in one lesson of Fletcher versus Peck is that the court says, and the reason I say it's about freedom of contract, because in that case, the court said, contracts are valid, and we are going to uphold contracts, and the government cannot go back and change the contract. And of course, you look at, countries where that's not true. Putin, I suppose he can change any contract, anytime he wants to, and that's not the world we want to live in, and that's not the one that's developed. But the other point is that you need to understand that courts are changing over time. In the original reading of the article, does anybody remember the term in there that was used, laissez-faire? Can somebody tell me what that means? Anybody know? Or where that comes from?
It comes from France.
It is a French term that's used in English. Like, we have a lot of French terms that we use in English. And you know what laissez-faire means? Translators. It basically means just leave everything alone, let things happen the way they will, and don't intervene, don't tell people what to do. But in the point that made in the article was that in American law, there was a certain time in our history where the court said, we're going to have total freedom of contract. We're not going to tell anybody what to do. We're not going to tell anybody what can be in their contract. And what was happening at the time was big, basically oligarch monopolies had so much power that they could tell people, oh, you have to work 20 hours a day, 7 days a week, and you never get a break, and you don't get any money. And the government, American government, came in and tried to change those laws and say you can't exploit workers like that you can only make them work for so long, and you have to pay them a certain amount and provide certain benefits. And the court said, no, you can't, the government can't do that, because laissez-faire, let's just let the chips fall where they may. Let's let people do what they want because it's freedom of contract. But the other side of that was the workers were not really free to contract. They didn't have any power. And so what the court was really doing is saying the people who have all the power get to decide everything, and the government pushed. And anyway, the court changed and stopped ruling that way, and now allows the government to, American government, to come in and put limitations on contracts and what companies can do. And so the point you have to understand is that the courts are changing all the time, and certainly in a common law system. And so we have some of these cases today. Another thing about Fletcher versus Peck, remember, is that I don't know your name. But he made a good point. The man who sued in that case was mad because the other person hadn't kept his promise. Now, the guy who bought the land, he got his land. There was no problem with that. But he was mad there was a promise broken, and that was one of the original theories of the development of contract law, that it was all about a promise that you made and you broke the promise, and that was the legal theory in which the case was brought. The cases that we read for today, and like I said, anybody read those cases, and did you understand what that concept was? Somebody tell me in one word what it is that the courts started saying: to have a real contract that you can enforce, you have to have something besides a promise. And you may tell me what that is, what the word for it is. They just, in all these cases.
Okay, when you create a contract, you have to have the guarantees. Like, if you create a contract, the parties of this contract should have guarantees which secure them, if I understood right.
Well, you're on the right track. But what's the word, the term that it'll be very important for you to understand if you're negotiating with American lawyers someday, to understand this basic term that's at the foundation of a contract.
Guarantee? No.
Well, the first case is about a guarantee, and one to make that promise enforceable as a contract.
Is it a consideration? Isn't
And
it?
that's the word. You had to have consideration for the contract. So can somebody tell me what after reading these cases, you have an idea what consideration means as a legal term in English?
Well, it's like negotiations, when each party met each other and they discuss their obligations and the concept of the contract and so on.
Yeah, you're on the right track. It's just like, so Fletcher versus Peck, they're arguing about the promise. He broke his promise, I'm going to sue him. But this idea of consideration is like, you have to give something for the promise. A promise by itself is no good. I can promise you I'm going to do something, but if I don't get something from you for the promise, you can't make me keep my promise. And that's that's bad. That's not honest. You made a promise and you didn't keep it. But in the law, there has to be something attached to the promise, which is what all of these cases are about consideration. This early, I didn't make y'all read it, but one of the leading common law cases, Cook versus Oxley, decided in England in 1790, and that's kind of an important time because what's going on between the United States and England in 1790? Who knows your American history?
England was a kingdom.
Yeah, well, England was a kingdom that used to control America, the colonies, and the colonies had revolted. And so 1790 is when the United States is just establishing its own government. So when the colonies were first established in the American colonies, all the law they follow is the English law that came from England, but in 1789, that's when the United States, after having thrown the British out, like y'all want to throw Russia out of Ukraine, was starting its own country. So it's a but anyway, that's the time that it happened. And in that case, the two people in the suit, one of them, the defendant in the case, the defendant, I don't want to be too basic, make sure everybody understands, the defendant's the one being sued, and the plaintiff is the person suing in the case. And the defendant had promised to sell the plaintiff 266 hogsheads of tobacco, 266 barrels of tobacco, and told the plaintiff, you have till 4 o'clock to agree if you want to buy the tobacco. And so the plaintiff by 4 o'clock said, yeah, I want to buy the tobacco. So that was keeping in terms with the agreement. But then the guy didn't sell him the tobacco. And the court struggled with this idea of like, was there consideration for the promise? And said when the guy promised that he would sell if the other guy agreed by 4 o'clock, he hadn't, they get into this really weird to us now argument over, whether that initial promise is enforceable, because the original promise was not made with any consideration. And that leads us into our 3 famous cases. And part of the reason we're reading these is these 3 cases, Hay versus Brooks and Daugherty versus Salt and Springstead versus Neese, are famous cases that everybody studies. But and let's start with the hardest one first. This Hay versus Brooks from England in 18 something, I forget. Anybody tell me what that case was about?
That case was about, like, we have 3 people, 2 main characters. Hay, his plaintiff, and Brooks, he's a defender. Hay, he sold cotton to Lee's, and Brooks, he agreed to guarantee that debt to plaintiff, and he convinced Hayes to give like a written agreement in exchange for money, 10,000 pounds. That was the case, and the problem was that Lee did not pay his debt.
Well,
like that.
You're doing a good job trying to understand this crazy English case, which I'm not sure I understand it, but what has actually happened here is similar to the case I just talked about. We had promises made at different times, and the English court struggled with, can you have a contract when somebody promises, the promises are not made at the same time? This is very important when you think about modern commerce. You have all kinds of contingent promises. It's easy to make a contract, if you meet somebody at the border, like in these olden days, and they have peaches that grow on their trees, and you have arrowheads that you want to trade, and you trade peaches for arrowheads, and that's easy. I give you the arrowheads, you give me the peaches, and you go home. But what about the case where they agree they want to trade peaches for arrowheads, but they're not right at the border. One of them has to put the arrowheads in a ship and send it, for 2 weeks to the other person to take the arrowheads to trade. And you can see that's how modern commerce developed, where all these promises are not being made at the same time. They're not exchanges occurring at the same time. And the early courts struggled with that that concept. So so the issue here was, so actually Brooks guaranteed somebody else's debt. And this was kind of a complicated transaction for these days. In terms of, so Hay had already given Lee 10,000 pounds to buy some cotton. And he was probably buying it from Georgia or Alabama. That's where the cotton came from. And the issue that they fought over was, so Brooks had already advanced, the money had already been advanced to Lee before Brooks came along and said, I will guarantee it. And so then there was like, well, there was, the money had already been given, so there was no no what for the promise, no consideration. And does anybody remember, and we want another thing to notice about this, if you read it, this case went back and forth in the courts several times, several different trials, went before several different courts to decide this really kind of stupid question. And anybody remember how the court finally resolved the question of consideration? There were a couple of problems. One, the court said when Brooks gave the guarantee, the money had already been advanced to the other person, so there was no consideration for his guarantee. So therefore, it was not enforceable. It was no good. There was also the issue of there was no stamp on the agreement. And this is important, and it's kind of important in Ukraine, but yeah, in Ukraine, everybody likes to stamp everything, put an official stamp on everything. And that's the way it used to be in England. And agreements were enforceable because of the form. It wasn't necessarily because of the promise or because of the consideration. An agreement was enforceable if somebody had put their wax seal on it, the viceroy, and stamped it, then that's what made it an enforceable agreement, just this kind of formality. But in this case, they're developing the theory of contract law, and they're trying to bring a case under, does anybody remember, it's a strange word you probably never saw before, what kind of case they were trying to bring about this argument over the guarantee? It's an old English word. And I think it's probably in the first part of the case. Let me see. I can pull up my copy of the case while I'm talking to y'all. Yeah, here it is. Yeah, it's in the first sentence. Somebody read me the first sentence of Hay and Another against Brooks, 1839 in England.
We have to read it?
Yeah, just somebody read the first sentence.
Okay, I can do it.
Okay, good.
Declaration in assumpts.
Yeah.
Didn't
Anybody stop and go like, What the hell is that? What's an assumpsit?
Well, I don't know the translation.
Nobody know? Did anybody look it up?
Wait.
So, yeah, so this is something important, you know, if you don't understand the third word, you might have a problem understanding what the case is about. Actually, it's not that important, but it's important historically because assumpsit was the theory under which people first started being able to enforce their contracts in the courts. And remember, in England, we talked about the first day, in the beginning, the courts didn't even want to hear contract claims because they had the idea that's an agreement between individual people and that's not the court's business. We don't want to even hear their contract claims. And they developed this theory where the courts finally started hearing contract claims, and assumpsit was this old crazy English word, I guess comes from Latin somewhere, of the theory they developed to be able to enforce a contract in court. And assumpsit was a special kind of action you could bring to try to enforce a promise or get a remedy for a breach of contract. And assumpsit was a particular kind of action you could bring on a promise that was not under seal, which means nobody had put their wax seal on it. And think about, this is crazy to us, but in the original days, that's what made it enforceable. Somebody had put their wax seal on it and stamped it, and that made it enforceable. Didn't matter what else happened. If it didn't have a seal on it, it was not enforceable. And I guess that, you know, authenticated the document that you could know that was a real contract. It wasn't a you know, fake contract. It had somebody's seal, and that's what made it enforceable. And this idea of assumpsit, I gave you a little history lesson. I think it's kind of interesting. Emerged in the English courts in the 1400s. That means the year 13 something, which is, you know, 700 years ago or so. And the theory of assumpsit came up in a case where somebody had hired somebody to transport their horse. And, you know, back then, your horse, that was a valuable thing. That was like your Mercedes. Now it's like your horse. And rich people had horses. And rich person hired somebody to transport his prize horse somewhere else. And they were ferrying it across a river. And you understand, if I use a word anybody doesn't understand, just stop me. I might not know where a ferry is, like a boat that would carry things across the river. They didn't even not have bridges in those days, and so they ferried things across the river. Somebody's ferrying the horse across the river. They're very careless about ferrying the horse across the river, and the ferry turns over and the horse drowns. And this is really the first, what's now a contract case in English law. The owner of the horse sues the owner of the ferry, of the boat that turned over and drowned the horse, not because of under a theory of a breach of contract. It was under a theory that he was negligent, careless, and that's a branch of law that we call tort law. If you sue people now because they drive carelessly, they're drunk and they drive, and you have a wreck, you sue them, that's a tort claim. And so the original contract case in England was really brought as a tort negligence case in the 1300s over the drowned horse. And that was the first case. And eventually that theory that was introduced evolved. It changed from being a theory based on the negligence, the carelessness in managing the boat, into a theory to sue people for not keeping their promise. And that's where contract law developed in the English courts. And that was called assumpsit, suing somebody for breaching their promise on a document that did not have a seal on it. But anyway, with all that history aside, does anybody remember how the court in this case resolved this question that we talked about, this under this theory? They've come up with this theory that you have to have consideration for a promise. Promise by itself is no good. You have to have consideration for the promise. And in this case, there's a problem with the guarantee, because the guarantee may not be any good, may not be enforceable, because the money had already been lent to Lee before the promise was made. And so what was the consideration for the promise? That's what the court is struggling with. And it sounds stupid to us if you're scratching your head, just like you should be, because, you know, we've worked past this now, but this is the history of the courts, you know, trying to figure out this theory of how you can sue somebody and what you can sue somebody for. And they said, you know, might not be able to sue on the guarantee because when the guy gave the guarantee for the loan had already been made. So what was the consideration for the guarantee? Y'all follow that? No, no, maybe. But does anybody remember how the court resolved this issue? Do you remember, did they find that there was consideration for the agreement between Hay and Brooks? That's the first thing to understand.
They raised the possibility of that consideration that Hay that he gave money to Lee. They weren't sure. They were considering different theories.
Yeah, and what's the theory? Yeah, they do. They struggle, and like I said, this case goes to trial 3 different times in 3 different courts. They keep coming back and trying it again. But how does the court finally say there was some consideration? So we're going to say this agreement was good. What was the consideration according to the court? And let me see.
If I'm not mistaken, they decided that in the plea there was mentioned some guarantee, so they decide so it can be considered like it.
What can be considered? I'm sorry.
They said that the guarantee was mentioned in the plea, so it can be considered like the guarantee.
Yeah, so actually, the idea of consideration is that something has to be exchanged. Like if I promise I'm going to wash your car and I don't wash your car, you can't sue me. I promise, I broke my promise, but you can't sue me. But if I promise to wash your car for $10, that's consideration, right? I have a promise and I got something for my promise. And so the court here is like struggling for what was given for the promise. And what did the court finally come up and say?
10,000 pounds, no?
It actually was not the 10,000 pounds. That's a better answer.
Got it.
That's actually a better answer. He guaranteed, somebody had given 10,000 pounds, somebody had guaranteed 10,000 pounds, and the court didn't rely on that. The court said, and if y'all had a hard time reading this, you're not alone. But when they were negotiating, Brooks gave Hay a letter asking to be released from the guarantee. And the court said the letter was a consideration. He said he did give something for the promise. He gave him a piece of paper. So let me ask you this. So tomorrow, I'm going for my territorial defense training, like some of y'all might have already done. And since my Ukrainian is so terrible, I have to have an interpreter. And like, some of y'all speak good English, you might be able to be my interpreter while I, train on how to use a javelin or whatever. So I have a piece of paper here. I'll see that. Who would like to work all day as my interpreter in the territorial defense training for this piece of paper? No volunteers? Nobody wants to work all day for this piece of paper? Isn't that a good contract?
No, it's not.
No, it's well, would that be a good contract in Ukraine? I made an agreement with you. I gave you this piece of paper. Isn't that a good contract? And I wrote on here, I want you to be my interpreter. I gave you the paper. And that's literally what happens in Hay versus Brooks. They said, well, the paper that he gave him in the letter asking to be released from the guarantee, that was the consideration. The letter he gave him something. In Ukraine, if I give you this paper, is that good? Is that a good contract?
No.
No,
Why not?
because
gave
it's
you
just a
something.
paper.
Hmm?
It's just
So you're going to ask me, you're telling me you're going to ask me if this piece of paper is really worth a day's work interpreting, this is how you take apart a Kalashnikov, put it back together. You won't take this piece of paper for that? Well, that's literally what the court says in this Hay versus Brooks, is that, he gave him something. There was consideration. He gave him a letter. And so what they say, and this is the important principle, is like when people are bargaining in a contract, we're not going to question whether what one party gave was worth what they got. And it's actually, there's a term for it in English that comes from these cases. They call it a peppercorn. Do you know what a peppercorn is? So when you put salt and pepper on your eggs or whatever, the pepper is ground up from a little seed, and that's called a peppercorn, the seed that the pepper comes from. And so that was what they said in the early English language. And the courts, if you read this case, go back and read it, the court says, we are not going to examine the fairness of the exchange. We're not going to examine whether the piece of paper was worth the day's worth of interpreting. We're not going to examine it. And it's called the peppercorn theory. It's like, you can have any consideration, even a peppercorn. If I give you a peppercorn and say, Anastasia, would you please come and interpret for me at the territorial defense training all day? I'll give you a peppercorn. And this English court said, we're not going to examine whether that's fair or not. All right. And I'll just leave that there because that may have changed, but that's the original theory. And again, it's this freedom of contract theory. People they can make whatever deals they want to. And that's not necessarily true today in America. It may not, some of y'all may know more about Ukrainian law. If you do, be interesting to pipe in and say, the law in Ukraine is totally different. Okay. Well, let's leave the peppercorns and the pieces of paper aside for a minute. But what you should understand is is totally ridiculous to us now. But the court really struggled. And this case, like I said, this case went back and forth for years, went on for years. They're trying to decide whether there was consideration for Brooks asking for his guarantee to be released from his guarantee of the 10,000 pounds to buy the cotton from Alabama. All right. What about, we've got some more problems of consideration in this case, Daugherty versus Salt. Somebody tell me what that case was about.
It's about, I don't know, a whale?
Yeah, it is about a will.
Yeah.
Well, it's not really a will. It's like a will. So a will is basically, that's what you write. This is what I'm going to give to my children when I die. And
by the law? I don't know.
the next, and
No.
actually both of these cases are about promises about what's going to happen to my property when I die. In Daugherty versus Salt, remember what it's about? It's about an aunt and her nephew.
Yes, the case about 1 second, a boy of 8 years and his auntie. So the auntie promised $3,000
And
payable.
why did she promise $3,000?
What?
Why did she promise $3,000?
She just promised $3,000 payable at her death or before. She write a note where it said that she gave to the boy $3,000. And I honestly didn't understand this case because the plaintiff is boy of 8 years.
Yeah.
He's
So who is
too
suing
young.
who in this case? Do you understand? So that's another strange word in there. What's a testatrix? Did you see the word in there? A testatrix? What's that?
Yes, understand.
A testatrix, that's a word for a woman who promises something when they die. So what has happened here is the auntie, I like the way you've got your British accent for that, your auntie. The auntie promised her 8-year-old nephew. And remember, she goes oh, you're such a nice boy. I want to do something nice for you. I'll give you $3,000. And so now the auntie has died. And so that's the testatrix. That's the auntie. She has promised, and the 8-year-old boy is still not an adult yet. So he's represented by a guardian. And so the guardian is suing the executor of the auntie's estate. Do y'all understand what that is? So when you die, you have a will, there's somebody called the executor who keeps all the promises in your will. So the guardian of the child is suing the person who is administering the estate of the auntie who has now died. And he comes and says, I want my $3,000 that auntie promised me when I was 8 years old. And what happens? And it's another strange case of what? Consideration. And what does the court say about it? This, by the way, this you wouldn't recognize the name, but this Judge Cardozo was a very famous judge in America, had a lot of very important, famous decisions. This was maybe, in my opinion, his worst decision. And y'all may say, "Oh, professor, you're teaching us all these cases and then telling us they're all wrong. And what are we supposed to think about that?" And there are two things. One is, if you're the lawyer, you should be able to argue with the judge and keep the judge from doing stupid things like this. Why won't the judge give the boy his $3,000? Who thinks the boy should get the $3,000?
His parents?
Well, I'm asking
Guardian.
you, my law students, your opinions. His parents, yeah, they probably think he should get the $3,000. Who out of all of you in the Zoom audience think the boy should get his $3,000, for crying out loud? Nobody thinks the boy should get his $3,000?
Well, his auntie wrote a note. Well, it means something. It was her will.
Well, it's not. Yeah, well, it's her will in terms of her intent. You know, be careful the way when you're a lawyer, you got to be very careful the way you use words. So a will means two different things in English. A will is a document, instrument you write that says how I want to dispose all my property when I die. Your will also means your intent. This is what I want. And actually, that's where the word will comes from. This is what I want when I die, but it also means what I want. So it's not really her will, because this is not in her will. This is something she did outside of her will. And you're right. She didn't write a will. What did she write?
A note.
A note. So the 8-year-old boy has a note. It says, "I, auntie, agree to give my nephew $3,000. Now, it's very important here to go like, why did auntie say, "I want to give my nephew $3,000"? Did he mow her lawn? Did he wash her car? What did he do for the $3,000?
She wrote there, "You have always done for me, and I have signed this note for you. Now do not lose it. Someday it will be valuable."
Well, that's an interesting point. She says, "You have always done for me." So is that consideration? She's saying, "You've done stuff for me." Is that consideration?
Not really.
Well, that's what the judge decides. I mean, what does the judge decide at the end of the day? Does he give the boy the $3,000? To understand the case, you got to understand, did the boy get his $3,000 or not? That's pretty basic. Who can tell me, did the judge say, "Give the boy his $3,000"?
No.
No, he said no. Why not? Why can't the boy have his $3,000?
Maybe because the judge didn't believe that the note is real.
That's an interesting point that you raise, because I told you in the first class, in the American system, different in Ukraine, I don't know, somebody can tell me, the court is only supposed to decide the things that the parties raise, the issues they put in front of the court. Remember Fletcher Peck, which was what? That there are all these Native Americans living on the land that they were selling. Left out of the case, they didn't even think about it because the parties weren't interested in that. They were just arguing about their contract. They forgot about the people who actually lived on the land that they were saying, I now own this land, but they're Indians living on it. So when the executor of the estate was defending this lawsuit, why did he say, I shouldn't have to pay the $3,000? You just said it. What was the defense in the case? You just said it. You just have to put it together. The executor said, this is not a real promise. It's not a real note. I think this signature was forged. It's not really Auntie's signature. That was the defense. Is that what the court decided?
No. They refused to hear that evidence.
Yeah. And then that's another very stupid thing about the case is the judge says the boy cannot have his $3,000, but now we have to have a new trial to hear the evidence about whether the note was forged. What's the point of that? He's already said the boy can't have his $3,000. Why are you going to now have a trial to decide whether it was forged or not? It's stupid. The one important thing to understand is that in American law, English law, maybe the same in Ukraine law, is the judge is not really supposed to decide what happens. So, they actually had a trial in this case, and there was a decision that was made, and the judge threw it out. The judge said, the decision's no good, I'm gonna throw it out. And in American law, that's only supposed to happen if there is no way under any fact circumstances that the boy should have won his case. And Judge Cardozo here says there's no way the boy should win his case because there was no consideration for that promise. I don't care what else evidence there was, no consideration for the promise. And you want to argue with Judge Cardozo and say, don't make that decision. What are you going to argue? We mentioned one thing, which was maybe there was consideration for promise. Auntie said, little boy, you've done lots of things for me. Maybe that was a consideration. Maybe he did something for her and she got something for her $3,000. But what's another reason you would argue the boy should win? You mentioned it. You've mentioned it several times. It's like one word.
Okay, we can argue that this boy of 8 years old wasn't a creditor, so he didn't have any reasons to make this note falsificate.
Well, that's so here you've hit on the point, which is there's a note. There is a written instrument where the auntie says, little boy, I owe you $3,000. I will give you $3,000. Now, y'all have checkbooks. Y'all write checks from your bank. Said, if you want to buy a TV, you go to the store and you write them a check. Say, I pay to the TV store $3,000 for my 19-foot tall TV that I want to watch the football match on. And can the store take that check to its bank and deposit it and get your money? Y'all probably don't know what I'm talking about because nobody uses checks anymore. Everybody's like on their phone and whatever. But in the olden days, people had checks, so they actually wrote on a piece of paper. When you bought something, you write, you could give cash, or you could write a check and say, all right, I'm going to buy some groceries. Here's $100 to the grocery store. Grocery store goes, deposits the check at their bank, and they get your money.
But this may have some form of this check.
Well, that's, you've hit on an important word. Well, remember, we talked about a lot of, in history, what made contracts enforceable was the form. And that was like, it had the seal on it. If it's got the seal on it, with no questions asked, that's good. You have to keep the promise on that piece of paper. If I interpret for you at the American territorial defense, and you write me a check for my interpreter work, and I go to my bank and say, here's the check Anastasia wrote me. Do I have to go to the bank and explain to them why Anastasia wrote me a check? Or if you're in a business, so for example, I have used to do business in Argentina. That was great. I started a wine import company, importing wine from Argentina. So if I write, there was a note in this case. If I wrote a note to the Argentine winery, say, here, I'll pay you, Argentine winery, $40,000 US. Do they have to go explain to anybody what the note is for? We'll talk about this in one class. We were talking about commercial paper and all this stuff about notes, and which are promises to pay. A note is a promise to pay. A check is a promise to pay. I promise to pay you. So
I think in this, I don't know, document may have a goal, clue. I don't know.
might have a what?
Goal of
A
this
goal.
document.
Yeah, well, if I
And
wrote
we
a note,
need to write this.
if I wrote a note, and and actually in an international transaction, it's very complicated, and that's why this history is important, because I might write some kind of a note to the Argentine winery, and it doesn't say I'll pay you today. It might say I'll pay you 3 months from now for the wine you deliver today. Well, of course, in the cases we've read, like the courts are really saying you can't do that because you're promising something then and they're doing something now. It's all at different times and you can't do that. So, but the point is, I can write a note to the Argentine winery and I don't have to explain to the bank what it is. It just says I'm a note, I have to, then when the conditions on the note are met, then the bank is going to pay the Argentine winery. So this is a strange case by Judge Cardozo because it's not just a promise, right? So it would be a different case, right? If the auntie just said, nephew, I love you, I'm going to give you $3,000. And then the nephew goes, when the auntie dies, and says, give me my $3,000. What could the executor say or the court say?
Give me some proofs that you have a right to have
You're
that.
missing proofs because, well, there are two things. One, there's no consideration for that promise. It's like, I can promise to do something, but if you don't give me anything for it, you can't take me to court. But unless I write a note, and a note is illegally enforceable. And so Judge Cardozo, he treats this case really as if there is no note. But how does he get around the note? The problem of the note. Because normally you can take your note and get your $3,000, right? Argentine Winery didn't have to go to the bank and explain, well, Professor Humphreys promised us that he would, you know, if we shipped this Malbec to the United States, that then we could get money out of his bank. They don't have to do that, do they? No. So why is this little boy got to prove what's behind the note? Well, and begin.
She signed it. I don't know.
Yeah, so actually, so I'd say, Judge Cardozo, you're wrong. It's not just a what you call a gratuitous promise, that you made a promise with no consideration. You also wrote a note as a legally enforceable instrument, so which should be a different case. But the Judge Cardozo says, no, I know the note is no good, because he actually looks behind the form of it and says, there was no reason for Auntie to give the boy the money. You know, he didn't do anything for her. He wasn't a creditor. She didn't owe him any money. She didn't owe the 8-year-old boy any money. And he says that, I know that because that's what they testified. You know, the little boy's guardian said she wanted to give him the money because of her love and affection for him. And so Judge Cardozo said, even though there's a note, I know the note is no good because there was no consideration, because it's only for love and affection, and you can't, love and affection does not make a promise enforceable. It's not consideration, which will come as a bad news for a lot of people. But, you know, I would say it's a dumb case of the note you can collect on your note. And nobody said that the defendant tried to say the note is no good, it's forged. And the judge said, I don't need to worry about that because I know there was only love and affection. One thing to understand about these cases, they're crazy cases. They're truly insane. Like, why did they argue about this and go to court back and forth over all this? And same as with Fletcher versus Peck. In history, they kind of forget the crazy reasons for the decision. And they kind of forget, like, well, the little boy had a note. And so this case, you know, if you were in a case arguing about a note, you would never cite this case for the proposition that, hey, a note is no good. You signed a promissory note, unenforceable. That case doesn't stand for that, because that, as we say in Alabama, that dog won't hunt. That's like a no good idea. It does stand, has come down in history to us to stand for the proposition that you do have to have consideration for a promise to have a contract, and that I like you is not consideration. I say, you know, Anastasia, I really like you. I like you so much, I'm going to give you $1,000. Then Anastasia comes to me later and said, where's my $1,000? I say, forget it. I don't have to give you $1,000. I said I give you $1,000 because I like you, but that's not an enforceable promise. So some promises are enforceable, some are not enforceable. Okay. I want to, you know, running a little bit out of time for our Springstead versus Nice. We'll get to that next time. What I want to do, and we've kind of worked through this, but is my man Artem, waiting in the woodworks. I gave him a lot of exhibits to put up, which I haven't used because I don't know, just kind of. But Artem, if you're there, there's a let me see the name of this exhibit I wanted to put up and show everybody. And if Artem is not there, then I might have to, y'all have to bear with me. I might have to try to do a screen share to show y'all this. And that might be an adventure. Here we go. I'm going to try it because I don't think Artem is with us. Oh, I told you we would go slower today, and we're going slower. And if I have to start doing screen shares, we're really going to go slowly.
I'm sorry, I'm here.
Oh, Artem. Oh, thanks. So there's a document. It's called image case brief form. Can you put that up on the screen for everybody to see? I was going to show you this after we discussed 3 cases. Can everybody see it? I don't see it. I still see people.
No, we don't see.
Don't see it.
One moment.
Okay, this might take a second. If y'all want to go on a real adventure, I might try a screen share here. We need to, yeah, we'll practice this some more. It's hard to think and teach and answer your questions and then try to manage all these documents and things too. I think Artem is having a hard time putting it up. I'm gonna see if I can share it. Hang on just a second. So there it is. Up on my computer screen. I'm gonna see if I can share it with y'all. Do y'all understand what y'all means?
Yeah, we do.
I say, yeah, that means, oh, here we go. That's a particular, let's see if this will. Oh, I tried to click on it. That didn't work. Artem, can you click on that and get it to show to everybody?
I'm sorry. Can you repeat?
I'm trying to show everybody that image case brief form that you almost have your cursor on. It's highlighted in blue. That's what I see, but for everybody to see the actual document.
Артем, ти на
That
нього
one right there.
Да.
Can you open that? That's it.
Can you see? Is this document?
I don't see the document. I just see
No?
the little index.
Ні, класно ще раз.
Okay, now I see
Oh, I'm
it.
sorry. Yeah.
Y'all see it?
Yep.
Yeah.
Okay. So this little something, I'm springing on y'all. But this is how, and this might help y'all read these crazy cases. And actually the cases are going to get, I think, easier to read once we get out of the 1800s of England, because the way they talked and the way they wrote is just crazy to us. We can't understand it today. It makes no sense. And like, what the hell are they talking about? But what's on your screen now, this case brief form, this is the way that American law students are taught to, we've tried to go through and analyze these cases. And we'll talk more about this next week. But this is kind of the form in which we are taught to analyze the cases. So you read one of these cases, and the first question is, what is the issue in the case? Like, what is the court really trying to decide? And maybe what would be a good exercise for next week, these two cases that we discussed and we went back and forth, I want y'all all, since y'all don't have any new reading, y'all are so lucky. We were not that lucky in law school. They would dump reading on us. So much reading, we thought we would die. And then I remember when I started law school, they would have us read all these cases, and they'd have, these long cases, and they'd have 200 footnotes. And y'all understand what a footnote is? Yes, maybe. But I remember they gave us so much to read, and I thought, they're giving us so much to read, they couldn't possibly expect us to read all these little footnotes too. So I come into class one day, and the professor calls on me, he goes, Mr. Humphreys, in this case, Daugherty versus Salt, of course, it wasn't Daugherty versus Salt, I don't think there were any footnotes, but it was a case with a bunch of footnotes. Mr. Humphreys, in number 4, what is the, I was like, I thought I couldn't read all the footnotes. But anyway, that's one thing in law school, you find out that you're superhuman, that you can do things that you never thought you could do before. But y'all are lucky because I dumped a bunch of reading on y'all, but now I'm not dumping any more reading on y'all. But I want y'all to take this form. And I don't know if you can download it or copy it, or if there's a way to email it to all of y'all. I don't have all your email addresses, but maybe somebody does, maybe Artem does. And go through these two cases we discussed and try to answer these questions. And this is what an American law student would do. We would come into class after reading these cases. We would take each case and go like, what's the issue? What is the court trying to decide? And sometimes, as I said, what the court says it's trying to decide, I would say is not really the issue. So in Daugherty versus Salt, Judge Cardozo, to him, the issue is it an enforceable promise because the auntie said, I'm going to give this boy $3,000 because I love him? That's what Cardozo says is the issue. I said, and a couple of people raised the issues like, well, that's not really the issue. She wrote a note, and that's a different story. But anyway, what's the issue? And you might have two answers, like, this is what the court says the issue is, and this is what I think the issue really is. And then the next one is, we'll talk about this some more, the procedural posture. And that means what stage in the process is this case at? And remember, in Hay versus Brooks, it had already been tried 3 times and gone back through the courts. The reason that's an important question is on appeal, what the court has to decide might be a totally different issue from what the court would decide at a trial. And a good example is if you have a trial and you introduce a lot of evidence, say you put a witness on and the witness tells a story, and the court at the trial will decide whether they believe that witness or not. And when it goes up on appeal, you can't raise that kind of question anymore about was the witness believable. The appeals court will defer to what the trial court was decided. If it's a question of law, like was Judge Cardozo wrong? This was not a gratuitous promise, but the auntie just giving the boy the money because she loved him. The boy had a note. And, and the appeals court might decide that question. That's a legal question, not a question of the credibility of a witness or the credibility of some evidence. So anyway, so you have to pay attention to what stage the case is at. And then, of course, we talked about the key facts. what are the facts that the court relied on to decide the case? And again, as we've discussed, you know, what Judge Cardozo said was the key fact may not be what you think is the key fact or what I think is the key fact. So you might have two answers to that. This is what the court said. This is what I really think are the key facts, that it should have been different. And then what is the legal rule? Usually in these, even these common law cases, the court will reach out and come up with some kind of a rule, like in this case, you might say, you know, Judge Cardozo said, you know, there has to be consideration for the promise of the $3,000. That's the rule. And then the holding is how that rule is applied to the facts. So Cardozo says the rule is you have to have consideration for a promise to be enforceable. And then the holding is, under these facts, there is no consideration because love and affection is not consideration for a promise to make it legally enforceable. And of course, you might argue, well, Cardozo, you were wrong because there was a note and, you know, other things. But anyway, this is the framework that we use every time we read a case. Before we come to class, answer those questions. And so try to use it and see if it helps you understand these cases. Like I said, after we get out of the 1800s England, cases should be a little bit easier to understand what in the world they're talking about. But let's try that for next time. Everybody take your shot, and I'll be like the American law professor. I'll call on some people and say, you know, what did you say the issue was? And as a lawyer, and some people say, well, oh, professor, you know, when are you going to teach us something practical? You're telling about all these cases about guarantees in England in the 1800s. But the most practical thing you can learn is how to argue in an American court. And the way you define the issue might determine whether you win your case or lose your case. You know, how you know, what you argue as the key facts might determine whether you win your case or lose your case. If you're ignoring the procedural posture, if it's up on appeal and you're arguing about the credibility of witness, you're going to lose. You have to understand where you are in the process. And then, you know, what is the legal rule that controls, and then how you apply that to the facts. And we're out of time, but y'all don't have any new reading, but we'll try to spend some time on these two cases we discussed and see how well y'all can do. And by the way, this might be something y'all have on your exam. I got to figure out how to give 94 students a grade, and that might be something you would do as an exam question. Is I might give you a case and ask you to brief it and analyze it in this form. So, all right. So everybody have a good week. Next week, I might be coming to y'all from Poland or somewhere else. We'll see. But have a good week, and we will do these case briefs for the two cases we talked about today. And then we'll go on with these other cases y'all have already read, Springstead versus Nice and Matai versus Hooper, and whatever the other ones are that are already assigned. Let me see. I see there's some chatty here. See if there's any question I need to answer. Well, I can't see it. Okay. All right. Well, y'all have a good week, and I'll talk to y'all next Wednesday.
Thank you
Okay.
so
Thank
much.
you.
Thank you.
Nice talking to you. everybody.
Here's the lecture. Bye.
All right. Go ahead.
Have a nice day.
Thanks, you too.
Thank you.
Thank you. Bye.
Bye.
Goodbye.
Bye.